conviction and sentence are set aside. Any fine that the accused may have paid must be refunded to him as soon as possible. If the accused is in custody, he must be released forthwith, unless lawfully detained on another matter.
Please, the court, ma'am.
Case number 94 of 2025 in the matter of the state versus Manuel Evangelistus and 23 others.
The conviction in respect of each accused of contravening Section 34, subsection 1, read with Section 34(3) of the Immigration Control Act 7 of 1993, is set aside and substituted with the conviction of contravening Section 34, subsection 3, read with Section 34(1) of the Immigration Control Act of 7 of 1993. The sentences imposed in respect of accused 1 through to 24 are set aside and substituted with the following sentence. Accused 1 to 24 are each sentenced to pay a fine of 2,000 Namibian dollars or 6 months imprisonment, which are suspended for a period of 3 years on condition that the accused is not found guilty of contravening Section 34(3) of the Immigration Control Act 7 of 1993, failure to report to an immigration officer committed during the period of suspension.
Yes, please, the court, my lady.
Criminal review case number 95 of 2025 in the matter of estate versus Pius Mwatelulo and another.
The conviction and sentence are set aside. The accused persons must be released from custody forthwith unless lawfully detained on another matter.
Court, my lady.
Criminal review case number 96 of 2025 in the matter of the state versus Jason Matthias.
The conviction and sentence are set aside. The accused person must be released from custody forthwith unless lawfully detained on another matter.
Yes, please, the court, my lady.
Case number 66 of 2021 in the matter of Sacky Shanghala and 2 others versus the prosecutor general.
I and Mr. Lutwezi still appear on behalf of the state in this matter.
Mr. Shanghala?
My lady, I have a few issues to address before the commencement of the ruling. I'm appearing for certain accused persons in the main trial. I just want to inform the court the following developments that happened recently up to late yesterday afternoon, and which at the end of the day have a bearing on this matter. I can inform this honorable court that I have filed a docket notice with withdrawal with the court yesterday morning through the office of the registrar. I don't know whether or not same has been placed, and that is in relation to accused number 7, 8, 23, 25, 27, and 27 and 28. So basically I'm only on record as far as accused number 9 and number 26 is concerned. I've been relieved from my duties as far as accused 7 and 8 is concerned. I only received the note yesterday as far as accused number 8 is concerned. Same would be filed during the course of the day, as well as to inform legal aid. So that the record just reflect currently I'm only on record for accused number 9 and 26. Further to that, I've also taken note of the last court order that basically requests all the lawyers to be present at court today. My only challenge as far as accused 9 and 26 is concerned, I have a matter at 11 o'clock this morning, a continuation of trial before your brother Miller. So that is my submissions that I would like to make upfront before this honorable court. So that I then maybe perhaps then be excused, let's say 10:30, if by that time the court is not done with the judgment. As the court pleases.
Thank you. May I inquire what the basis of the withdrawal is?
Beg pardon?
May I inquire what the basis of the withdrawal is?
I just received notice from my clients and I'm not willing to discuss such publicly. I respect the private confidentiality and the privilege thereof, as the court is.
And you will also inform legal aid accordingly?
I will inform legal aid as far as accused number 8 is concerned, because I'm given a legal aid instruction for accused number 8 as well as for number 9. Number 7 was private, as the court is.
Mr. Mike Nghipunya. Do you confirm what your former attorney placed on record?
Yes, I confirm.
What will be the way forward as regards your legal representation?
I will appoint another lawyer, and I actually have engaged another lawyer, but I had done so when the matter was postponed to the 10th of November, so I had informed them to come on the 10th of November, so I will revise that according to what transpires today.
Who is your new lawyer?
Veiko Alexander.
Will it be Mr. Alexander himself?
Yes.
Thank you. May I inquire, have you provided Mr. Alexander with the necessary funds?
Excuse?
Have you provided Mr. Alexander with the necessary funds?
Yes, we have arranged that.
Thank you. Mr. Nghipunya, are you aware or do you know whether your lawyer is in possession of a copy of the disclosure?
Yeah, I was just engaging the states today to make arrangement for that, because we were 3 with one lawyer, so we only had one copy, and one of us is remaining with Mr. Engelberg, so which means the ones that are moving would probably have to get a copy, so Mr. Marlize will attend to that with my lawyer.
Mr. Marlize, you confirm?
We have no choice, my lady.
Mr. Shuudifonya?
Yes, my lord.
You had Mr. Engelbrecht on instructions of legal aid.
Yes, I do confirm.
Mr. Engelbrecht, let me rather ask you, Mr. Shuudifonya, will you proceed with another legal aid attorney?
Yes, I will do.
Thank you. Mr. Engelbrecht, will you kindly inform legal aids accordingly so that they, as a matter of urgency, can appoint.
I will engage them during the course of the day. After, let's say, during the afternoon, I will inform them. But maybe perhaps that if the court order is then available, maybe by tomorrow, that I can also attach the same.
Thank
As the
you.
court pleases, but I will attend to them.
Thank you, sir. You may be seated. Any other preliminary matters, Mr. Siamunji, Mr. Ilago? Maybe you can just place yourself on record.
May it please you, my lady, I do appear for accused number 1 in this matter.
Please you, my lady, stay on record for accused 5, 10, 12, 13, and 14. May it please the court.
Accused number 4, Mr. Esau. Do you know where your lawyer is, or do any of the counsel have instructions to appear on his behalf?
I didn't get any instructions to stand.
Neither did I, my lady.
Mr. Esau?
I was not in touch with my legal counsel on this very appearance for today because we were prepared for the 10th of November appearance, but not for this one.
Thank you. Mr. Marandetsi, has Mr. Bekes been in contact with you?
He hasn't, but I noticed that the court order was served on all the parties involved in this case, my lady.
Yes.
Yeah.
Ruling. This court on 8 September 2025 gave a ruling in respect of the 3 appellants' application for further particulars in terms of Section 87 of the Criminal Procedure Act 5 of 1977 as amended hereinforth the CPA. The 3 appellants filed an application for leave to appeal on 22 September 2025 and the matter was heard on 7 October 2025. Only the first respondent, the Prosecutor General, opposed the application. This application for leave to appeal was filed in terms of Section 316, subsection 2 of the CPA, and the respondent pointed out that the application should have been brought in terms of Section 316, subsection 1 of the CPA. I agree with the respondent, but I am willing to overlook this error on the part of the appellant and do not deem the error fatal to the application. In its ruling on the applicant's application for further particulars in terms of Section 87 of the CPA, the court made 8 separate orders, some of which were in favour of the appellants and some of which were not. The application for leave to appeal does not state which of the 8 orders the appellants wish to appeal against, nor do the nor do the grounds of appeal specify in respect of which specific order the grant of appeal is raised against. Section 316, subsection 2 of the CPA reads as follows. I quote, "Every application for leave to appeal shall set forth clearly and specifically the grounds upon which the accused desires to appeal," end quote. The appellant's 5 grounds of appeal consist of 26 paragraphs spanning 8 pages and as quite rightly pointed out by the respondent, are akin to heads of argument. Legal conclusions are drawn from numerous references to case law. The following was recently stated in State v. Yartse at paragraphs 20 to 21. I quote, "The notice of appeal must contain clear and specific grounds of appeal that indicates whether the appeal is brought against issues of law or fact or both. It is a requirement that an application for leave to appeal states specifically and clearly the grounds on which the appellant relies on, which the court should consider to grant him or her the relief sought in the application. The principle on proper grounds was set out in the case of State v. G. van Pythius and another, where the court held that grounds stating that the magistrate misdirected himself on the facts or law, that there were material irregularities during the proceedings, and overemphasized the importance of other facts are not grounds but conclusions drawn by the drafter of the notice of appeal," end quote. State v. Kakololo at 8F states that the grounds of appeal serve to inform the trial magistrate in clear and specific terms which part of his or her judgment is being appealed against. The court continued in the Kakololo case to elaborate on why it is necessary for the grounds of appeal to be clear and specific by stating as follows, quote, "It is with reference to the grounds of appeal specifically relied on that the magistrate is required to frame his or her reasons under Magistrates' Court Rules 67 subsection 3 or sub-rule 3. Once those reasons have been given, the appellant may amend the notice of appeal under sub-rule 5, and the magistrate may again respond to the amended grounds of appeal. The notice also serves to inform the respondent of the case it is required to meet and, regard being had to the record and the magistrate's reasons, whether it should concede or oppose the appeal. Finally, it crystallizes the disputes and determines the parameters within which the Court of Appeal will have to decide the case. Consequently, it also serves to focus the minds of the judges of appeal when reading the sometimes lengthy record of appeal, researching the law in point, considering argument and adjudicating the merits of the appeal," end quote. The appellant's ground of appeal fall far short of this requirement, and for this reason alone the application for leave to appeal should be struck from the roll. However, in the interest of judicial completeness and clarity, the court posed the following question to the parties during the hearing. Given the wording of section 316 subsection 1 of the CPA and the fact that the ruling on the appellant's request for further particulars was of an interlocutory nature, is the ruling appealable? In response to the court's invitation, Mr. Marondetse, appearing for the respondent, simply referred the court to S versus LK and boldly stated that the decision in LK is authority that all rulings are appealable, even if they are of an interlocutory nature. This is simply not correct. The decision in S versus LK is authority only for the position now applicable in Namibian law, that the state is entitled to make use of the provisions of section 316A of the CPA to appeal against a perceived lenient sentence imposed by a court or quo. The state, having thus in effect conceded that the ruling of this court was appealable, the first appellant, who addressed the court on behalf of himself and his co-appellants, declined to address the court on the question posed. The parties have been given an opportunity to address the issue that the court will decide below, and thus the court has done its duty by them as required in accordance with the rules of fairness. Section 316 subsection 1 of the CPA reads as follows, I quote, "An accused convicted of any offence before the High Court of Namibia may, within a period of 14 days of the passing of any sentence as a result of such conviction, apply to the judge who presided at the trial or, if that judge is not available to any other judge of that court for leave to appeal against his or her conviction or against any sentence or order following thereon, in this section referred to as an application for leave to appeal, and an accused convicted of any offence before any such court on a plea of guilty may, within the same period, apply for leave to appeal against any sentence or any order following thereon." End quote. It is clear from a reading of section 316 subsection 1 that the section only applies to an accused who has already been convicted and sentenced and who wishes to appeal against his conviction and or sentence and or against an order following his sentence. Our jurisprudence has, however, over the years developed to allow an accused to appeal to the Supreme Court in circumstances other than that envisaged by a reading of section 316 subsection 1 of the CPA. State versus Strowitsky already in 1994 dealt with the question whether interlocutory orders are appealable in terms of section 316 of the CPA, and concluded as follows at 271D, I quote, "When regard is had to the plain words of the section, an accused convicted of any offence, my emphasis, that is the only construction which can properly be given to it. In other words, section 316 does not permit an interlocutory appeal prior to conviction." End quote. In State versus Manuma and others, a number of accused who were charged with high treason pleaded in terms of section 106 subsection 1F of the CPA that the court, I quote, "did not have jurisdiction to try them since they were forcefully removed from within the borders of Botswana to stand trial in Namibia." The court rejected their special plea and they noted leave to appeal against the said ruling of the High Court. Relying on Strowitsky above, Manyarara AG ruled that the application for leave to appeal by the accused was ill-conceived and irregular and struck the application from the roll. Manuma followed short on the heels of the closely related case of State versus Mushwena and 12 others, where the High Court upheld the identical special plea in respect of Namibia's lack of jurisdiction over the 13 accused, and where the state's petition to the Chief Justice for leave to appeal to the Supreme Court was successful. The important difference, however, between the Manuma and Mushwena cases was pointed out by Manyarara AG at paragraph 16, where the following was stated, I quote, "Mr. Small also pointed out that the crucial aspect of the granting of leave in the petition field in the matter before Judge Hoff is that, in upholding the special pleas, the learned judge ordered that the accused be released. In other words, the learned judge's order brought the trial at an end, paving the way for the Prosecutor General to apply to the learned judge for leave to appeal against his judgment, and when this was refused, the Prosecutor General was entitled to go further and petition the Chief Justice." End quote. It is clear that there is a general rule against piecemeal appeals in criminal trials, specifically against rulings made in respect of interlocutory orders. This is, however, not a rule set in stone, and it has been held that in exceptional circumstances, interlocutory orders may be appealed against. In State versus Lamek and others, the question whether a presiding officer's refusal to recuse himself was appealable was answered in the affirmative. In support of its decision, the court referred to Rex versus Milne and Adley, where it was stated at 6H that a judicial officer who declines to recuse himself where he is clearly biased commits an irregularity in the proceedings every minute he remains on the bench during the trial of the accused. The court in Lamek proceeded to summarize the position as follows at paragraph 18. I quote, The appealability of a refusal to recuse oneself as a presiding officer goes beyond the consideration of the provisions of Section 316, subsection 1 of the Criminal Procedure Act, namely to the competence of the presiding judge himself or herself to define the parties' rights and to grant or refuse the relief claimed. It is appropriately compared to a plea that a court has no jurisdiction to try a case. Such a plea is appealable, end quote. It is clear that exceptional circumstances should exist before a court will depart from the general rule governing leave to appeal in interlocutory orders. In Nghipunya versus Gebiedsmagistraat Ondangwa, the court was asked for a mandamus ordering the prosecutor to provide further particulars to the charge the accused were facing. The court remarked as follows at page 652, paragraphs D to E, I quote, "As has been emphasized many times through the decisions of our courts, the High Court will not lightly interfere with undetermined criminal proceedings emanating from the lower courts. Each case must be considered on its own merits, but the High Court will only interfere in order to avoid a gross injustice or where the just adjudication of a matter cannot be obtained in any other manner." End quote. Translation from Afrikaans, my own. This then begs the question how the refusal of an application brought in terms of Section 87 of the CPA in the two benchmark cases of Scholz and Shabalala and others versus Attorney General of the Transvaal and another ended up before the Supreme Court of Namibia in the Scholz matter and before the Constitutional Court of South Africa in the Shabalala matter. In Scholz, the court remarked as follows at paragraph 2 to 3 of the judgment, I quote, "That leave was granted on the understanding that only one ground of appeal was to be argued. That ground is that the Honourable Judge erred in law to order that certain witness statements are not privileged and should be made available to the defence. During the trial, an application was made on his behalf for the disclosure by the Prosecutor General to the accused of the witness statements of these witnesses who had not yet testified. Judge Hanna granted the order directing the Prosecutor General to produce the specified witness statements. In passing, it is proper to mention that the respondent has no interest in the appeal. He was acquitted on one count of murder and one count of attempted murder. This appeal and the judgment thereof have wide implications and effects on the administration of justice, and more so on the work of the Prosecutor General's Department. It was for this reason that, after hearing argument, this court made and handed in an declaratory order. We did not want to delay the consequences following from our judgment." End quote. In the Shabalala matter, the following was stated at paragraph 4, I quote, "Notwithstanding these conclusions, Judge Kluter was of the view that, because of their public importance, a ruling should be given by the Constitutional Court on a number of constitutional questions raised by the applicants made on behalf of the accused. Relying on Section 102, subsection 8 of the Constitution, he accordingly made an order referring the following questions for decision by the court. 1. Whether a court interpreting the Constitution is bound by the principles of stare decisis to follow the decision of a superior court, or whether such a court may hold that a decision of such superior court, other than the Constitutional Court, is per incuriam because it incorrectly interprets the Constitution. Whether Section 23 of the Constitution can be utilized by an accused in the exercise of the rights contained in Section 25, subsection 3 of the Constitution, and if so, whether the accused should have access to the police dossier, and if so, to what extent, under what circumstances, and subject to what conditions, if any, such access should be exercised." End quote. As was mentioned in this court's ruling, both these decisions were brought about by the coming into existence of the South African as well as the Namibian constitutions, and the question whether an accused had a constitutional right to have access to the witness statements contained in the police dockets constituted, as is clear from the portions of the two judgments quoted above, exceptional circumstances which prompted the judges in the quota quo to refer the matters to the respective higher courts for adjudication. The Scholz and Shabalala matters therefore confirm, rather than water down, the general rule that exceptional circumstances have to be present before leave to appeal will be granted in respect of an interlocutory order. In State versus Malumu, the court Akwa ruled certain confessions inadmissible, some on the grounds that the magistrate who took the confessions did not explain the right of the accused to apply for legal aid, and some on the grounds that they were not made freely and voluntarily. The State was aggrieved by this decision and brought an application for leave to appeal, which was dismissed by the court Akwa. The State then proceeded to petition the Supreme Court, giving rise to the case which I refer to in this paragraph. Since it was the State who applied for leave to appeal, the application was brought in terms of Section 316A of the CPA, which reads as follows. I quote, "The Prosecutor General may appeal against any decision given in favor of an accused in a criminal case in the High Court, including any resultant sentence imposed or order made by such court, any order made under Section 85 subsection 2 by such court to the Supreme Court." End quote. Counsel for the State argued that the words "any decision" as used in Section 316A subsection 1 should be given a wide interpretation and that it should not be interpreted subject to the same limitations as contained in Section 316 of the CPA, which confers a right of leave to appeal only to a convicted person. Section 316A subsection 2 states that the provisions of Section 316 in respect of an application or appeal by an accused referred to in that section shall apply mutatis mutandis with reference to an appeal in terms of subsection 1. End quote. The Supreme Court did not agree with counsel for the State. At paragraph 30 of the judgment, the court considered the import of the words mutatis mutandis and came to the following conclusion when it stated that the State's interest in appeals will arise when there is an acquittal of an accused, and for purposes of Section 316A subsection 1, the above words referring to the words convicted as used in Section 316 subsection 1 are to be replaced by the word acquittal. The importance of this conclusion of the Supreme Court for the decision at hand is the fact that the court then proceeded to provide 3 reasons why it deemed a restrictive interpretation of Section 316A to be necessary. It can safely be stated that the reasons enumerated by the Supreme Court are nothing less than policy considerations underscoring the general rule against interlocutory rulings being appealable. Hereunder is a summary of the 3 reasons for the Supreme Court's restrictive interpretation of the words any decision as used in Section 316A subsection 1 of the CPA. A. It must be accepted that the legislator was aware of the rule against piecemeal appeals, and if it had wanted to allow such a practice, it would have done so in clear and unambiguous language. B. Allowing the State to appeal any decision in favor of an accused would conceivably lead to appeals which will end up being of only academic value in the instances where an accused is in any event convicted at the conclusion of the trial. C. The court acquos ruling on the admissibility of the confessions were of a pure interlocutory nature, in the sense that they were capable of being altered by the court acquo itself. Continuing, the Supreme Court later declared the interpretation of the words in a decision in Maluma 2 restrictive, but I will submit that 3 policy considerations above remain a reflection of and relevant to current Namibian jurisprudence and are therefore applicable to the case at hand. This court at paragraph 104 of its judgment referred to what was stated in State v. Lamek at paragraphs 19 to 20, I quote, "The difficulty which arises for the court is that it will not know whether the further information requested by the accused is contained in the docket. In that respect, the court must rely on what the parties say. If, as in the instant case, the state alleges that the information is contained in the contents of the docket which was disclosed to the accused and that is not challenged, the court will accept the assurance given by the state," end quote. This court continued at paragraph 108 as follows. "The proverbial flip side of the coin is that our courts do not look kindly on trial by ambush, and should the prosecution wish at trial stage to use information or documents that were not disclosed to the accused persons involved in this case, they will most certainly have to make out a case for such to be done. Although not explicitly so stated, the implication should be clear that the court will order further disclosure by the state if and when the need arises throughout the trial and if a sound basis for such an order is set out. A document that was, for example, ruled to fall under litigation privilege, as referred to in paragraph 91 of the court's judgment, and which the state later wishes to use as evidence against the applicants, will then conceivably be ordered by the court to be disclosed to the applicants. This paragraph of this ruling should in no manner be interpreted in any other manner than as an example used to illustrate the point the court is making. Such an order will clearly alter the order the applicants are currently appealing against, and as such, it falls squarely within the meaning of an interlocutory order, namely an order which can at a later stage and under certain circumstances be altered by the court itself. I accordingly find that there are no exceptional circumstances before me which would convince me to grant leave to appeal to the Supreme Court. I am also not convinced by anything placed before this court that there is any gross injustice present or that the just adjudication of a matter cannot be obtained in any other manner. For the reasons above, I make the following order. The application for leave to appeal is struck from the roll.
Court, my lady.
Yes, I will ask my assistant to provide copies for all.
As we have 21 days to consider if the petition is viable.
I understand. Okay, as to the way forward, I have noticed going through the quite voluminous record of this case that already exists that no proper pre-trial conference was held. Mr. Marondetse, the state duly drew up a pre-trial memorandum.
Yeah, that's correct, my lady.
However, none of the accused or their legal representative replied to that pre-trial memorandum.
That's correct, my lady.
Yes. Thank you. So that is where we are at the moment. I have had regard to Practice Directive 35 issued under Rule 3 of the High Court rules and the contents thereof. It is apparent, given first of all the number of accused, Second of all, the number of counts that the various accused, some collectively, some individually, are facing, and the number of witnesses involved in this trial, that we cannot continue without this matter being sorted out. We cannot walk blind into this trial. In the light of that, the court will then make the following order. It will be included in the court order so that all are clear on what is expected of them. 1, the following directives are given in terms of practice directive, hereinafter referred to as PD 35-2, issued in terms of Rule 3 of the Rules of the High Court of Namibia. A, the state must compile a pre-trial memorandum which shall comply with the following core directives. 1, each inquiry in terms of PD 35 shall refer to a specific accused or accused persons. 2, each inquiry in terms of Practice Directive 35 shall refer to a specific count or counts as contained in the indictment. Such pre-trial memorandum shall be served on each accused or his legal representative on or before 4 November 2025. B, each accused shall in writing reply to the state's pre-trial memorandum on or before 18 November 2025. The accused's attention is specifically drawn to Practice Directive 35-2E. The accused shall file their reply to the state's pre-trial memorandum on or before 18 November 2025. The matter is then postponed till 25 November for a pre-trial conference.
Please the court.
As it pleases the court.
Mr. Shanghala?
Please, the court, my lord.
Yes, Judge. Thank you, Judge. Just two things. I appreciate that for the first time, the judge in this matter acknowledges that we have not held pre-trial conference, which I've been asking for ad nauseum. I'm sure you've read it in the record. I've been accused that I am seeking frivolities and delaying the trial. Yet today, you acknowledge that a pre-trial conference has not been done. Secondly, had we responded to that pre-trial summary of substantial facts and the pre-trial memorandum in 2021, it would have happened in the absence of a full disclosure. It's still not yet full, by the way, notwithstanding your judgment and walking back some of the conclusions that I thought you had made. If we had responded with it being prejudiced because disclosure was not made, and it's still not complete. The last one was made in July to Mr. Engelbrecht and not to me, who asked for the Section 31 referrals. Still, the Section 83 reports that I'm telling you are still missing. Yes, you can shake your head all you want, but today it is monumental that all this talk of we have been delaying the trial. By the way, you would have seen, Judge, that there are blue chairs here. Yes, I've been delaying the trial, suddenly there are blue chairs here. But still, the work is not done there. No plugs, there's nowhere for me to put, as you can
Yes, they're working on it.
Yes. But now, two things technically just to talk about going forward. As you can see, this is the record in the appeal regarding the issues that have been taken by Mr. Late Justice Shimengo. That now the problem is that I've already filed everything. I've now received the acknowledgement that I've been seeking that we should go into pre-trial proper. This will have to proceed, unfortunately, otherwise we're just waiting for the day. Secondly, Judge, I see that there's a screen there, behind you there, there a way that you can order that we have access to it so that when the trial begins, we can be able to project documents? They're quite voluminous, the documents. We can deal with that during the pre-trial conference so that we're able.
Yes, I will contact the technical department because me, myself, I will not know.
Yes, and the issuance of plugs in here and little places where we can put the documentation, because ferrying it from.
Yes, they are. The plan is to put counters there where your papers
I
are
see.
now.
I see. I feel acquitted. Second, and lastly, Judge, I read the registrar's directive that you gave us. It refers to members of the media. I'm not a member of the media, and you have acknowledged that the running record is not yet available. I have written to your research assistant through her and to the registrar to request for the running record. I still don't have it. If I am able to record the audio, I can transcribe it myself if need be.
Yes, unfortunately, I am not in a position to grant that request. However, I will take it up with the Office of the Registrar.
Yes. Alternatively, I can simply turn it on my computer. You wouldn't even know. I'm being very kind to us. So the point is, it's just that we would require it for the purposes of trial preparation. I'm sure you can see it, even for the court and anybody else's use. I'm being directed to the directive itself. It says that the judge may make that determination. I'm not so sure what, but we can take it up on the 25th of November.
Yes. Any of the legal representatives, anything to add?
Equally nothing from my side, ma'am.
Nothing from my side, my lady.
Mr. Marandete, anything to add?
Nothing, my lady.
Mr. Esau, thank you, Mr. Marandete. I am going to ask you to be in contact with your legal representative. It is not acceptable for him to be absent. The court order, I am informed, was served on him. So if he is not able to be here, then we should make arrangements. It is, however, imperative that he is here on the 25th of November.
Note taken, my lady. What I want to emphasize as well is that there was an order by Justice Liebenberg dated, that was on the 22nd of April, 2021. An order for the full disclosure by the state to be made to council. And that was supposed to have been done on the 6th of May, 2021. But today, up to today, that full disclosure was never honored in fact, by the state. When I was on my bail, fake bail, disclosures, that was in 2023, the year 2023. Disclosures were made from Angola. That was 2 years after 2021. Disclosures were made from Iceland. And as I'm standing here today, on this year, the first quarter of this year, that was in March, April, further disclosures were made. And I want to assert my constitutional right. My constitutional right of Chapter 3, Article 12, that this trial must start in a reasonable time. It's 12(1)(b), if I'm not mistaken. And I want to assert that very right, because I'm feeling that I'm privileged, prejudiced, in fact. I'm prejudiced, and I want this very court to take a decision on that very matter now. I submit.
Yes, the court takes note of what you have said, sir, and I agree with you as far as at least that you are, of course, entitled to a speedy trial. At the risk of sounding coy, the only manner in which that is going to happen is if we start with the trial. And this is what I am endeavoring to work towards by ordering a proper pre-trial conference so that we are all on the same page, so that we know what the disputes are, we know what you do not object to, what evidence the state is intending to lead in respect of which count, in respect of which accused, so that as soon as that is finalized, barring unforeseen circumstances, we can start with the trial. Please adhere to the court's directives as regards the practice directive. If you deny any allegation contained in the state's pre-trial memorandum, state the basis for that denial so that we can proceed. Case remanded until the 25th of November, the 25th of the 11th month, for a pre-trial conference. I will make that 10 o'clock in the morning. All attorneys, please be present. If you cannot be present yourself, please ask somebody of your office to attend the pre-trial conference and make sure that they are properly briefed. Mr. Marandetse, is it your request that accused 1 through to 9 be remanded in custody?
That's correct, my lady.
Accused 1 through to 9 then remanded in care of the Bantu Correctional Facility. Accused number 10, bail extended. Court adjourns.